Good evening. Today is May 17th of 2024. I hope everybody's had a good day so far. And I want to talk tonight about an important historical event from exactly 70 years ago. A decision made by the United States Supreme Court. There were two major civil rights cases that were decided during the month of May 1954. 2 weeks ago, I talked about the May 3rd decision, Hernandez versus Texas, which had to do with discrimination against Mexican Americans in jury selection. Tonight, I wish to talk about the much more famous case related to school desegregation, Brown versus Board of Education. The two decisions were 2 weeks apart. They appear back to back in the U.S. reports. It was on this day, on May 17th of 1954, the U.S. Supreme Court ruled unanimously that racial segregation in public schools violated the 14th Amendment to the Constitution, which prohibits the states from denying equal protection of the laws to any person within their jurisdictions. The decision declared that separate educational facilities for white and African American students were inherently unequal. It thus rejected as inapplicable the public education, the separate but equal doctrine advanced in 1896, according to which laws mandated separate public facilities. They said they could be separate as long as they were equal. The Plessy case involved Homer Adolph Plessy, who was an octoroon, that is, he was 7/8 white, 1/8 black. And according to the infamous one-drop rule, which was applicable in Louisiana at that time, anyone with any trace of African ancestry was considered black. And he could pass very easily for white, and there would have been no problem, but he let his ethnic background deliberately be known in order to challenge the Supreme Court ruling. And he lost the case 8-1. And this was precedent to uphold separate facilities from 1896 to 1954. I believe that's 58 years. In the late 1940s, the National Association for the Advancement of Colored People, the NAACP, began a concentrated effort to challenge the segregated school systems in various states, including the state of Kansas. And they chose Topeka as a place for the test case because the schools there were relatively equal. They were able to bring in expert testimony to demonstrate that segregation was bad for African American children, even in places where the schools were relatively equal. And there were several other cases that they dealt with about this time, but Brown was first argued on December 9th, 1952. The attorney for the plaintiffs was chief legal counsel for the NAACP Thurgood Marshall, who in 1967 would become the first African American to serve on the Supreme Court. It was re-argued on December 8, 1953, to address the question of whether the framers of the 14th Amendment would have understood it to be inconsistent with racial segregation in public education. Writing for the court, and by the way, when what happened in 1953 was very significant, when Chief Justice Fred Vinson died suddenly. At the time, the new president, Dwight D. Eisenhower, appointed Earl Warren as the Chief Justice. The Warren Court, and Warren was on the court from 1953 to his retirement in 1969, a time of mass change in American history. And Earl Warren did not come to the court with any liberal credentials to speak of. The Warren Court, seen as the golden age of liberalism. Earl Warren was a Republican, governor of California. In 1948, he ran on the Republican ticket for vice president, along with New York Governor Thomas Dewey. They lost the election to Harry Truman. But 1952, Earl Warren, as governor of California, sought the Republican presidential nomination when it was obvious he wasn't going to get it. He withdrew from the race and threw his support behind Eisenhower, whose main opponent was Ohio Senator Robert Taft. After Ike became president and Fred Vinson died, he appointed Earl Warren as Chief Justice. Beginning with the Brown decision and with many other decisions that Warren made, Dwight D. Eisenhower later referred his exact words of his appointment of Earl Warren. He said, "That was the worst damn fool mistake I ever made." But once a Chief Justice or any justice is appointed, they can't be unappointed. They can be impeached. They can be removed. As a lengthy process. No justice of the U.S. Supreme Court's ever been impeached. There have been some lower federal judges who've been impeached. Ironically, one of them was a Mississippi judge named Walter Nixon, no relation to Richard Nixon, who would have been impeached had he not saw the handwriting on the wall and decided to resign in 1974 from the presidency. But many cases led up to the Brown decision. And it was Earl Warren who held that inequalities existed between schools in the space in the case before him, in spite of the fact that children attended separate schools solely because their race created them a feeling of inferiority. They had to be bused a considerable distance to attend segregated schools. Many thought that was A-OK when they started using school buses to achieve racial balance in schools. They started screaming bloody murder. A subsequent opinion on the Question: Brown versus Board of Education 2. It was argued April 11th and through the 14th of 55 and decided on May 31st of that year. Warren ordered that the district courts and local school authorities take appropriate steps to integrate public schools in their jurisdiction with all deliberate speed. Some districts in the South interpreted that to mean all deliberate speed. They could take up to 100 years if they wanted to. And this is certainly considered a milestone in American civil rights history. The case and the efforts to undermine the decision brought greater awareness to racial inequalities and the struggles African Americans faced. The success of Brown galvanized civil rights activists, increased efforts to end institutionalized racism throughout American society. And there's been progress. At other times, there's been regress. The man whose name is associated with the case is Oliver Leon Brown, an African American welder and minister in my denomination, the African Methodist Episcopal Church. And is recruited by the Topeka NAACP legal action to one of several parties to this case. And hold on, Oliver Brown et al. Versus Board of Education of Topeka. And his daughter Linda was the focus of much of the media attention. Sadly, Reverend Brown died in 1961 at the age of 42. In 1988, the nonprofit Brown Foundation for Educational Equity, Excellence, and Research was founded by Oliver Brown's family along with the Topeka community members to preserve the legacy of the Brown decision. And it was on October 26, 1992, that President George Herbert Walker Bush signed the Brown versus Board of Education National Historic Site Act. And he had three daughters, Reverend Brown did. The most famous was Linda Brown, born February 20th, 1943. And again, she had to attend an all-black school much further from her house. But she won the right to attend a school that was close to her house. And it was ruled that race discrimination was not constitutional at all. Throughout her life, she continued to have early access to advocating equal access to education in Kansas. She worked as a Head Start teacher, a program associate in the Brown Foundation. She was a public speaker and education consultant. And she was married 3 times, had 2 children, and she passed away on March 25th, 2018, at the age of 75. And survived by her grandsons and in addition to her lifelong advocacy of law and education, her legacy includes the declaration of historic landmark status for both Sumner, the nearby whites-only school she sought to attend, and Monroe, a more distant segregated elementary school. She's become a symbol of African American legacy, and she died in her longtime hometown of Topeka, March 25th, 2018. Although her family wouldn't comment, Kansas Governor Jeff Collier paid tribute to the woman who sparked one of the landmark cases in American history. At the time, 2018, he said, 64 years ago, a young girl from Topeka, brought a case that ended segregation in public schools in America. Linda Brown's life reminds us that sometimes the most unlikely people can have incredible impact, that by serving our community, we can truly change the world. We extend posthumous thanks to both Linda Brown and her father, my fellow AME minister, Reverend Leon Brown. Thank you for all you did 70 years ago, and have a good evening to everybody listening.